What up, Doe Biz Nation? This is your boy Tay Biz TV. We are here to drop a video about the former Kentucky sheriff accused of killing a judge. He appeared remotely from jail during court hearing recently. Okay, and so this is according to ABC News. The article is written by Bruce Schreiner from the Associated Press, and so we're going to go ahead and discuss this particular event real quick here about this crazy case of the sheriff Shawn Stines, who gunned down the judge of Letcher County in Kentucky by the name of Kevin Mullins. And so we did drop some videos and let you know about the fact of the whole sex for work or sex for favors scandal that happened in the judge's chambers. There's actually a video camera in the judge's chambers, which is not even heard of really when it comes to court and chambers and things of that nature. So we're going to deep dive into this real quick. We're going to also take a look at the full video of the court hearing as well. So go ahead and like, share, subscribe to Tay-Biz TV. Here we go. All right, it says here, former Kentucky sheriff accused of gunning down a judge last year, stunning their tight-knit Appalachian community, appeared remotely from a jail Friday for a court hearing as defense attorneys and prosecutors discussed preliminary matters that will lead up to his murder trial. All right, now, so former Letcher County Sheriff Shawn Stines has been jailed since the slaying last September, but his attorneys indicated they will ask that bond be set at another hearing not yet scheduled. Okay, this is very, very interesting. Circuit Court Judge Christopher Cohron said he would be glad to address bond at that particular time. So look here. Christopher Cohron, who is a judge, a circuit court judge, he was appointed, he was selected and chosen by the Supreme Court of Kentucky and ordered the U.S. Supreme Court to be the appointed judge for this particular case from now until the end of it. That means he's going to be the trial judge for it as well. So there's not going to be any other judge but Christopher Cohron. All right. It was the first hearing before Cohron since his appointment last month as special judge in the case, again appointed by the Supreme Court. Defense attorney Jeremy Bartley said the matter of whether Stein should be released on bond had been in limbo until Cohron's appointment. Stines is accused of fatally shooting Letcher County District Judge Kevin Mullins in the judge's chambers. Mullins died at the scene, and Stines, who was sheriff at the time, surrendered without incident. So we did, on this channel in particular, we did see that when we looked at the video and we looked at the entire, actually the first hearing of the grand jury when he got indicted, we looked and saw that once he did gun down the judge, what happened was he just completely walked in the hallway and he mentioned something, and he uttered the word saying they are trying to kidnap my family, or they're trying to kidnap my wife and child. And so that's where it got really interesting. And then we discovered that there was a sex for favors scandal going on since like 2022. And so Ben Fields, who was he was a former bailiff I believe he was a former bailiff of this particular judge as well. He was involved with doing this sex for favors. He was actually one of the ones who was in control of the ankle monitoring system that was for the women in the prison or women in the jail. And so Sabrina Atkins is one of the witnesses and one of the actual women who was involved in getting sex for favors, sexual favors, so that way she didn't have to pay for her ankle monitor and things of that nature. So it's very, very wild. This case runs very, very deep into some waters that are very, very steep. All right. It says here that Stines was indicted by a grand jury on one count of murder of a public official. The ex-lawman pleaded not guilty. He pleaded not guilty of first-degree murder. He resigned days after September 19th. The September 19th shooting at the courthouse in Whitesburg, an Appalachian town about 100 miles southeast of Lexington, Kentucky, near Virginia border. The video of the judge being shot was played at a dramatic court hearing last year. The video without audio showed a man identified by police as Stines pulling out a gun and shooting Mullins as he sat at his desk. And Mullins was actually sitting at his desk. He was smoking a cigarette. They had just had lunch prior to this. So that's very interesting as well when it comes to this case. It says here that the man walked around the desk, pointed the gun at the judge, who had fallen to the floor, and fired again. And it showed that Stines could face the death penalty if he's convicted of the murder charge. Participants in the court hearing Friday appeared via video conference. Stines showed no emotion as he sat quietly behind his lawyers at the Eastern Kentucky jail where he's being held. It says here that Bartley's told the judge that defense lawyers are reviewing voluminous amounts of potential evidence provided by prosecutors. It said it could take prosecutors another 4 to 6 months to amass all the potential evidence and complete any testing, prosecutor Jack Steele said. Okay, very, very interesting. They are still going through discovery from the prosecution. 4 to 6 months. So it might be 4 to 6 months before we even get a trial date. Okay, because everything right now is just stemming from more discovery. They do have to do forensic testing on the phone. Remember, Judge Mullins had Sheriff Mickey Stines' daughter saved in his phone. Okay, and in the video, he calls his daughter from the judge's phone. He calls the daughter from his phone, and then next thing you know, there's a shooting. All right, and in the midst of the shooting, if you look at the video very carefully, in the midst of the shooting, you will see that there is someone who is calling the phone back while the judge is being shot by Sheriff Mickey Stines. This is the most interesting and most fascinating case that I've ever could think this would ever happen. All right. But we're going to hold off on our comments and all that kind of stuff right now. We're going to go ahead and go to the actual court hearing. Here's the video. Here we go. Let's go.
We're here on 24 CR 204, Commonwealth of Kentucky, Shawn versus Shawn Mickey Stines. This is my first hearing on this matter. I was appointed to sit as special judge in this matter by the Chief Justice of the Supreme Court. So I will be the sitting judge in Letcher Circuit Court till the conclusion of this matter. Also, the Honorable Courtney Shoemaker, who is the Circuit Court Clerk for Boyle County, is going to be the Special Circuit Court Clerk. For the record, the parties are present. Jack Steele is the Commonwealth's attorney in this matter, and Jeremy and Carrie Bartley, I see, are both present.
Yes, Your Honor.
With their client. I wanted to set this first status hearing. I know we'll probably have a few of these just to kind of go through a few matters to make sure we're going to proceed efficiently during the pendency of this action. Mr. Steele, can you first give me kind of an update as far as proceeding with discovery and kind of what you think a reasonable timeline is for discovery completion on this case?
First, Judge, let me clarify. Ramsey Dallin with the Attorney General's office, also attorney handling the matter. She had a conflict with other scheduling issues today. I see Mr. Cohron, Attorney General's office, on special prosecutions. Ramsey has really been taking care of the discovery. I know we have made discovery. I think 2 weeks ago we made another some more discoveries, some issues. We still have some things coming in and things being tested. I would think within the next 4 to 6 months, all discovery and testing would be complete.
Okay. Mr. Cohron, you wish to input on that at all? Or anything you can update us on?
No, Your Honor. Jackie is correct. That sounds correct. And Ramsey, when she gets back next week, she's out of the state this week, but we'll have a better idea at that time.
All right.
Your Honor.
Go ahead.
If I may, Your Honor, I also failed to mention Mr. Jim Cox, who is co-counsel with our office. He is appearing by Zoom as well, Your Honor. And if I may speak to discovery, they have provided a plethora of voluminous discovery. We're continuing to go through that. At this point, all of our discovery requests have been met. And at this point, there are no outstanding discovery issues that we're aware of.
All right, and I encourage, like I said, Mr. Bartley, I know any request you have, please go ahead and make it, and they'll be happy, I'm sure, to provide that. If we do become, at any point in time, if there is an issue in regards to discovery, all y'all need to do is notify my office, and we can address that at any point in time the parties need.
Yes, Your Honor, thank you.
All right, next, there's been an affidavit of indigency filed on behalf of Mr. Stines. Mr. Steele, have you had the opportunity to review that yet?
I have not, Your Honor. No, sir.
Yeah, I'm, Mr. Bartley, if you don't mind, or I'll tell you what, if it's okay with you, I'll send Mr. Steele a copy of that for his review also.
Yes, Your Honor. Yes, Your Honor. Then I would ask that if we have any hearings relative to that, Judge, if we could do those in camera, Your Honor.
Absolutely,
Yes, Your
absolutely.
Honor.
And Mr. Steele, I'm gonna have you take a look at it. I'll just kind of give you my inclination at this point in time, after reviewing the affidavit of indigency, due to the nature and complexity of this case. I do believe after reviewing the affidavit of indigency that Mr. Stines will qualify potentially for Chapter 31 funding. I'm going to ask you, I'll send that to you, and you can copy special prosecutions on it. What I would ask is, after I send it to you all, if you all have any objection to that, if you will file that with the court within 10 days.
Yes, Your Honor.
And I don't think that will be an issue. Mr. Bartley, once we get that issue resolved, I will then proceed potentially with any request for Chapter 31 funding. And Mr. Steele, Mr. Cohron, maybe you all can address this if you want. Obviously, the rules would require that you all be given notice of the request for any ex parte hearings. Without question, there I think will be some ex parte hearings potentially for Chapter 31 fundings. How do you all want Mr. Bartley to notify you all anytime that they are going to file for an ex parte hearing?
Your Honor, Mr. Bartley has both mine and Ramsey's email. We've emailed each other several times through the last several months. Email will be fine. He does not need to file those in certified record.
I appreciate that. That's always, the Chapter 31 process is of such that that first step, the notice requirement, I don't think needs to be formalized. So any point in time, Mr. Bartley, before we'll have a hearing on that, if you'll just notify Mr. Steele in regards to that, and we'll address that at that point in time.
Thank you, Your Honor. Thank you, Mr. Steele, Mr. Cohron.
And then next, are we in a position to know if there's going to be a request for any type of evaluation?
Judge, I've spoken with my client. We have. Oh, my apologies, Judge. I thought you were speaking. So what we have spoken with Mr. Steele about is that we do believe that there will be an issue as to criminal responsibility. We have consulted with, folks with regards to that issue. I reached out to Mr. Steele and we basically decided that we would raise this as a joint motion. I know that, once we provide that notice, the Commonwealth is entitled to have their expert evaluate Mr. Stines. And out of expediency, I believe that Mr. Steele and I would ask for an order for that evaluation to go ahead and take place. There are a couple of issues I did want to address with regard to the examination. I don't think they will be an issue at all, but I did want to make a couple of notes. But that's how we intend to proceed, Your Honor, with the court's blessing.
All right. And in regards to what I generally would do, and I think that's probably the best course of action, to go ahead and get that in the pipeline. It is going to require, what I would recommend is that we go ahead and get the order entered in regards to competency and criminal responsibility. I might as well go ahead and that address, since we're going to be doing that. versus we've seen it sometimes be piecemealed, and I don't want to delay the proceedings if we would have to go back and redo that. I know KCPC will initially do a video interview of him initially, and then we'll notify, which is now required by law, and then they will then notify the court if a inpatient evaluation would be required.
Your Honor, so and I understand the court's position, and certainly we do not raise the issue as to competency, but I understand the court and the expediency of going ahead and examining that. I understand that, but I did want to make clear that our notice only concerned the criminal responsibility, Your Honor.
Okay.
But the other issue that I wanted to make sure that we discussed was my understanding with the, I believe it's Shawn's law that made it more clear that our expert should be able to participate in the proceedings at KCPC. And I would ask that I'll go ahead and identify him as Dr. Eric Drogan.
Okay, I'm very familiar with Dr. Drogan.
We would ask that Dr. Drogan be allowed to participate pursuant to the statute. And then the second piece of that is, and generally I believe this is standard procedure, but I believe that normally KCPC gives both parties an opportunity to submit materials that they may want reviewed.
Sure.
We certainly would like to make sure that we have that opportunity.
Absolutely. Yeah, both sides will have. I know the more information the KCPC's provided, the more effective the evaluation will be.
Yes, Your Honor.
All right, Mr. Steele, what's your take on if we do just criminal responsibility, or if we go ahead and knock out competency and criminal responsibility?
I'm okay with the competency issue. This is taking a little bit of a turn from the discussion me and Mr. Bartley had. I thought we was doing a competency evaluation. They always do the criminal responsibility behind it. But now he's saying that he wants his expert there during a criminal responsibility. I'm not comfortable doing a criminal responsibility if he's going to have an expert on that position, unless we know what the issues are they're raising in the criminal responsibility with our expert. So we're going to get in a position where our experts at KCPC or the court's experts at KCPC are on criminal responsibility are going to make a finding while their expert's present, and then he's going to go back and write his report. I don't want the court's KCPC evaluators doing an evaluation until they know what their position is, what their expert's position is. That way he's not interfering, but he's in an evaluation for criminal responsibility, and then he gets to go back and then address issues that he thought were not discussed properly during the KCPC responsibility issues. So I'm okay with getting the order in, but I think there should be I think their expert, if they've already conferred with him, he's already done an examination, needs to get that report in before the KCPC responsibility issue is done.
Yeah. So, Judge, I don't think that the rules require preparation of a report before that examination. We are, again, we raise only the issue of criminal responsibility. I understand that it's expedient to raise both, but once we give notice, there's nothing that I see that requires us to produce a report before he's evaluated. And, I guess the reverse could be true that, if we have them evaluated, I mean, if we submit the report, then the inverse is true. Then they get the opportunity to see our position in advance and to evaluate it, in that light, Judge. So I'd ask that we go ahead and send him up there, have him evaluated. If there is something, once we both exchange reports that in rebuttal they want to have reviewed by their expert, then I think certainly they can send them Dr. Drogan's report and have them examine it, Your Honor.
All right. I'm going to take that under advisement. I am going to go ahead and get an order entered. We'll address the issue of the timing of the providing of the reports and who's present and when. I want to take a look at that Mr. Bartley, I mean, for me, the distinct difference would be KCPC, while they're an employee of the Commonwealth, are not an agent of the Commonwealth. That is an independent evaluation versus Dr. Drogan, who would be a retained defense expert. So,
If I could, Your Honor, I don't mean to interrupt you, Judge, and I think that if this were a court, I mean, if we were only looking at the issue of competency, but I believe under 807, if we have our own expert and we're not asking them to serve as an independent, I mean, this is going to be the state's witness. I mean, KCPC will be their expert. And Mr. Steele, do you disagree with that position or that piece of it?
Judge, if I may at this point in time, that's exactly going to my point. If he was indigent from the get-go and he had been found indigent and I understand the court may be looking at that issue, they're required to use state funds available before coming to you for Chapter 31 funds. Also, they had funds available for them for an expert in criminal responsibility. That is their expert. They're not sending him for a criminal responsibility competency issue to be addressed for the court to have an understanding, for them to then say, okay, there's criminal responsibility issues. They have got an expert hired. They're putting the court and the Commonwealth in a position that they're going to allow criminal responsibility done. Well, they've already got an expert hired. And like the court said, they're not my expert. They are a function of the court for the court to look at issues in regards to pretrial issues. So that's again, just reemphasizes my position in regards to criminal responsibility, why their expert who's already hired should have a report filed before that goes forward.
all right. I'm going to take that issue under advisement. I'll take a look at that. I will either issue an order or I'll enter a briefing schedule in regards to that issue.
Sure.
Thank you, Your Honor.
All right. Anything else you all want to address today?
Yes, Your Honor. We would ask that the court advise how you would like us to make our request for bond. We had discussed at the arraignment with the previous judge that we would do a formal bond hearing. Certainly, we were kind of in limbo until your appointment, Your Honor. So we certainly would ask the court to review it, but we would like the opportunity to address bond, Your Honor, and how, in whatever form the court would like for us to raise that issue.
I'm fine, but I'm in regards to issue that if you want to set a time for a formal motion on your bond, we can do that at any point in time.
Yes, Your Honor. Yes, Your Honor. In terms of dates, is there any parameter in which you would like for us to file it?
If you all want, you can confer with the Commonwealth. If you want, just find some agreeable dates to both sides, and then we'll coordinate that with my office, and that'll be a hearing that I will travel and do that in person.
Yes, Your Honor. Yes, Your Honor. That's why I want to make sure that it was convenient for all the parties.
Absolutely. We'll work around that. And when we get a little bit more, we can probably tie it in, and also with the fact that if we need to have any arguments in regards to the evaluation process, we could probably couple that and kill two birds with one stone.
Yes, Your Honor. In the event that the court, there were a bond set that was makeable, then at that point we, may have to revisit whether there's a inpatient versus outpatient. But I understand, Your Honor, we'll file that motion and get with everyone to discuss a convenient hearing date, Your Honor.
Sure. Be glad to address bond at any point in time.
Yes, Your Honor.
Anything else we need to address today?
No, Your Honor.
All right, Mr. Steele,
Nothing for the Commonwealth, Your Honor.
Mr. Cohron, anything from the AG's perspective?
No, Your Honor, nothing else. Thank you.
All right. I appreciate all the parties. I will then look for you all to look for some dates once the bond motion is filed. And then we'll set a time to have that heard, and then we'll finalize any of the issues in regards to the evaluation of Mr. Stines. So if there's nothing else with that, court will be in adjournment, and then we'll reconvene upon an agreed upon time with the parties.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
All right. Thank you all.
Yo, so you just saw the video, you just saw the court hearing. There was some criminal responsibility issues going on that they had to discuss, Chapter 31 funding and things of that nature. And so I want to break that down real quick if we can about Chapter 31 funding and let you know what that actually is, just in case you're not aware of what it is. All right, so let's look that up too as well. Let's go. This Chapter 31 funding in Kentucky is a program that provides educational benefits and vocational rehabilitation services to veterans with service connected disabilities. The program is also known as Veteran Readiness and Employment. Okay. Eligibility consists of veterans with service-connected disabilities that limit their ability to work, active duty service members who expect an honorable discharge and have a service-connected disability rating of 20% or more, service members who are participating in the integrated disability evaluation system. Okay. The benefits of this is it helps veterans prepare for, obtain, and maintain employment, helps veterans explore employment options, address education or training needs. Also, helps veterans live as independently as possible. There's an application process. You can apply for Chapter 31 benefits online at VA e-benefits by completing a VA form. You can also contact your local VA regional office for more information. So it sounds like in this particular case here, it sounds like that Mickey Stines is saying that he was indigent and that he did not have funds and, all the amenities and things that he needs in order to, continue this case on. However, that's what the filing of Chapter 31 is all about. And so the prosecution is like, hey, if you knew that you were, suffering, or you knew you needed something from the get-go, then all this should have been stated. And also, we do have state funding for things that you may need. So the prosecution is not trying to let up at all on this case at all. They're not trying to have any type of level of understanding about that at all. Do they make a great point? I'm not sure. You let me know what you think in the comments. But this is a very, very interesting case that's been going on 4 to 6 months of continuous discovery, voluminous amounts of discovery, and things that the defense have to go through in order to prepare themselves for this trial. So let me know also what you think, how long this trial is going to be. I mean, you're talking about a 4 to 6 month discovery process here, or time frame, I should say. And when the trial starts, then how long is the trial going to be? Is it going to be a month? Is it going to be 8 days? Is it going to be 2 weeks? Is it going to be a month and a half, 2 months, 3 months? Like, how long is this trial going to take place? Let me know what you think. Let me know what you're coming up with in your mind. Until next time, this your boy Tay Biz TV. Yo, like, share, subscribe to the channel, and I'm out. If you want more content from Tay Biz TV, go ahead and subscribe to the channel. Hit the notification bell, man. Peace.